Hi, this is Alan Gassman. Welcome to Thursday, August 20th. I'm here with Ken DeGraw, and we are going to talk about what CPAs need to know about bankruptcy and working opportunities for CPA firms and similar professionals in bankruptcy. Please set your calendar for next Thursday, the 27th, for part 2. Please also note our email addresses here. I will be checking my emails during this presentation and of course after the presentation to try to answer these while we're speaking. Otherwise, we will get back with you afterwards. There is a book called What Every CPA Lawyer and Financial Advisor Needs to Know About Bankruptcy on the LISI program. Ken and I are probably going to update this book in the next 3 to 6 months. But if you buy it, let us know and we'll make sure to give you the update for free. I'm always plugging the Notre Dame Tax and Estate Planning Institute. It is October 29th and 30th. It is a wonderful, wonderful experience. Professor Hesh has assigned a lot of interesting topics for brand new research papers, brand new presentations to nationally known and respected speakers. If you've never attended Notre Dame, you certainly now have the ability to do so because this is our first year of making it available by web, and that's going to be the only way to attend it. Also, there is a free webinar that you can go to if you go to the link there at the top right-hand side. We call it the Biden two-step. It is an estate tax planning discussion with Jerry Hesh, Marty Shinkman, and me. Ken, tell us a little bit about your practice, how you came into being the bankruptcy guy, and what this means for CPAs who may be watching and aren't bankruptcy people yet.
Sure. Thanks a lot, Alan. I'm Ken DeGraw. I'm a partner with Withum Smith & Brown. Withum's a national firm, offices primarily on the East Coast. We do have an office out in Irvine, California as well, along with an international presence as part of HLB International. I got started in bankruptcy a number of years back when one of my clients, who happened to be a bankruptcy trustee, said, "Hey, I need some help with this case. You interested?" And the rest is kind of history. From there, over the years, spent a lot of time working with trustees, creditors committees, debtors, creditors, as an examiner all across the board, and been able to, it's been an amazing experience. Finally, at this point, the last couple of years, the bankruptcy's been down a little bit. However, with the current environment we're in, it's expected to come roaring back, which is why I suspect we have the attendance we do today. So looking forward to kind of sharing some of that knowledge and helping some of our brethren kind of get up to speed with what they need to know.
Beautiful. So I'm going to give you control of these slides, Ken. I'm going to sit back and enjoy learning here.
Fantastic. So welcome everyone. Today we're going to spend the next 40 minutes or so just talking at a very high level about bankruptcy, the bankruptcy process, and what it's all about. Really just kind of get your feet into the water so you can understand the four corners of bankruptcy. And then ultimately next week when we get back together again, we'll talk a little bit more specific about some of the specific things that you do within a bankruptcy process as a financial advisor. Got to give you that disclaimer that some of the stuff we talk about today is going to be very general, very high level. If you've got a client who's facing a bankruptcy or financial distress, certainly seek out qualified legal representation who are knowledgeable in the bankruptcy and distress world, along with a financial advisor who's also knowledgeable. There's a unique skill set here that needs to be brought to bear, and it's not, they can't just do it with their typical corporate counsel or their regular accountant who's handling their tax compliance. Enough of that. So as financial advisors, we have a unique opportunity here, more so than in a lot of other areas where we work with legal counsel in a particular matter. And that's because bankruptcy by its nature is a result of a financial issue. The legal environment is simply the means to cure the financial problem that exists. So the attorneys, by and large, lean very heavily on the accountants and financial advisors that they're working with to help them develop the information and knowledge to get through that process. All of the skills that you've developed as a financial professional over the years are brought to bear, whether that be forensic, financial, valuation, tax, it all comes into play. Unlike a lot of the other areas where your forensic and valuation sections may practice, bankruptcy is a little bit unique. As I mentioned, we're not going to go into too many specifics today, but if at the end of this you decide that this is a world you'd like to learn more about, there are a number of national organizations out there that have a tremendous amount of information, as well as terrific networking opportunities where you can learn and grow. I'll name a couple of them for you. The American Institute of CPAs is certainly out there. I'm part of that as well. They will have a bunch of information coming out in the next couple of weeks, part of which I've written and or reviewing. The Turnaround Management Association is another one. For those interested in the turnaround space, a fantastic organization, a lot of great knowledge and information to be had. The Association of Insolvency and Reorganization Advisors is largely an organization of financial advisors in bankruptcy and distress situations. The International Women's Insolvency and Restructuring Confederation is kind of, as the name would indicate, it's specific for women, but is tremendous in terms of the knowledge and information and leadership that they bring to bear. And the final one I'll mention is the American Bankruptcy Institute, which is primarily legal oriented, but has just an enormous amount of information. So that's a lot, but those are buckets you can reach into and expand your skill set. So if we're going to play in this field, we need to know who the players are. And some of this is evident and some of it not so much. First, obviously, there's a debtor. There's somebody who's got some financial stress, whether it be an individual or a business, that needs your help. The financial advisor, that's you. That's the person who's going to bring their financial skills to bear to assist that debtor and legal counsel in resolving their financial pain. There's a trustee. A trustee is appointed in all Chapter 7 cases, and we'll talk more about that in a couple of minutes. They're also now appointed in all Subchapter 5 cases. Slightly different role, but know that there's a trustee out there. Their job, by and large, is to take all of the assets that the debtor has, convert them to cash, and pay them out to the creditors. It's way oversimplified, but that's the basic role. Of course, we have a court, we have a judge, we have someone that's there to call the balls and strikes and help the figure out, based on the bankruptcy rules, whether the debtor and the creditors that are arguing, who's going to win, who's going to lose, and make all the judgments and ultimately get to a discharge. The Office of the United States Trustee is a subsection of the Department of Justice. Bankruptcy is, after all, a federal issue, right? So the Office of the United States Trustee oversees all bankruptcy cases. They're there and they're involved, whether it's a Chapter 7, 11, 13, doesn't matter, they're there. There's something called an Unsecured Creditors Committee. In a Chapter 11, the largest body of creditors is typically the unsecured creditors. That's all the people who don't have some underlying security to their claim. The court doesn't want them all coming to court on any given day. So there's a committee formed to address their issues. And we'll talk more about creditor issues at the very end here. In some cases, there's an examiner. An examiner is typically appointed by the court, and that person's there to help the court specifically understand the issues that are being presented to them. A lot of times that becomes valuation issues where you can imagine the debtor is saying the value is X and the creditors are saying the value is Y, and somebody needs to understand all of the lengthy reports and information that went into those decisions. There are lawyers. There are lots of lawyers. There are lawyers for the debtor. There are lawyers for the creditors. There are lawyers for the United States trustee. The judge is probably a lawyer. The trustee will have a lawyer. They're all over the place. I see Alan laughing, but they are absolutely there. And of course, that kind of begs the question of who's paying all these people. The debtor estate will pay for the debtor's financial advisor and attorneys, as well as the creditors committee attorneys and financial advisors. And that's part of what runs up the cost of the bankruptcy, and it's always an issue. So now we know who the folks are. Let's talk about the chapters. Title 11 of the United States Bankruptcy Code, not to be confused with Chapter 11, has a number of chapters, and that lays out all of the various rules of the road that we're going to file as the debtor goes through the process. Chapters 1, 3, and 5, for some reason we skipped the even numbers, not quite sure why. Those are the rules. that underlie all of the various chapters that are going to be filed. Chapter 7 is a liquidation. So what's going to happen there, as I mentioned earlier, is a trustee is going to be appointed. It's going to grab all the assets, going to liquidate them, going to pay them to the creditors. Both an individual and a business can file for Chapter 7. And there's an individual filing for Chapter 7 needs to go through something called a means test. The means test was put in place back in the 2005 bankruptcy changes to make sure that people weren't taking advantage of the bankruptcy system. It forces them to file for Chapter 13, which we'll talk about in a second. They also, as individuals, have exemptions available to them. There's a federal schedule and there's a state schedule depending on where they're resident. That exempts certain of their assets from the bankruptcy filing. Now, we're not talking about significant amounts of money here, but there are two assets that are most relevant, and that is their home, their homestead, and their retirement assets. Different states have different homestead exemptions. Some of them exempt it completely, some of them not quite so much. It's important to know those differences. Retirement assets for qualified plans are always exempted from bankruptcy cases, and that becomes very relevant, particularly for small business owners who may be looking at the retirement assets and saying, you know what, I can keep my business afloat just a little bit longer. Businesses in a Chapter 7, though, are shutting down. They're locking the front door and they're handing the keys to that trustee. As we'll talk about in a couple of minutes when we talk more about the process, there's a lot that goes into that immediately after that front door is shut. Chapter 9 is a municipal bankruptcy. It's filed by municipalities when they get themselves into some trouble. I can only imagine what's going to happen coming out of this pandemic. So I would expect to see some more Chapter 9s. The most notable one of recent is Detroit. We're not going to spend any time talking about Chapter 9 because they're so infrequent, but just know that it's out there. When you think about bankruptcy, though, or you hear about it in the news, generally you're talking about Chapter 11. Chapter 11 is a reorganization, meaning the debtor, and it can be a business most often, can also be an individual if they can't meet the debt limits for a Chapter 13, are going to try to stay in control of their finances or their business. They're going to try and fix whatever it is that the problem was, cut a deal under court supervision with their creditors, and exit Chapter 11 as a shiny new debtor with a fresh start. Sounds wonderful, sounds great, doesn't quite work as smoothly as you would think, but that's conceptually what a Chapter 11 is. And we'll get into some of the process in a minute. Chapter 11, Subchapter 5, though, is a little unique. And I'll spend just a couple moments on that just because it's brand new and literally brand new. It came about in February of this year, as if Congress somehow had enough foresight to figure out that there was going to be a pandemic starting in March and they needed to do something about it way back in 2019. We'll get into politics. But the small Chapter 11, Subchapter 5 made some significant changes to Chapter 11. And it is by and large a Chapter 11, but there's some changes to address the cost and the time associated with a Chapter 11. There is no creditors committee, which runs up the cost significantly. There's a trustee appointed, but the trustee is largely there to facilitate the process. He's not there to control the process. There are very specific timelines that the debtor needs to file for the plan of reorganization with the court and get it approved, which cuts down that length of time that inevitably comes about with a Chapter 11. It's limited to those debtors with $7.5 million of debt or less right now. That will revert back to $2.7 million of debt in March of next year. The CARES Act bumped it up, but it was for just a one-year time window. The act itself came about as part of the Small Business Reorganization Act back in 19. If you're interested in Subchapter 5, and I definitely encourage you to get to know more about it, because I think it's a tremendous opportunity for middle market debtors. On the 24th, Monday, the AICPA will be rebroadcasting a webinar that I did with some other attorneys specific to that topic. So I would encourage you to check it out and find out what's going on there. Enough about Sub 5. Chapter 12 is dedicated to family farmers and fishermen. It's a reorganization process. Not going to spend much time there. Chapter 13 is solely for individuals, and it is a reorganization process where an individual will who's a wage earner, has consistent income, will try to rework their obligations out over a 3 to 5 year period. The big benefit to a Chapter 13 is that there are some protections for your home to kind of stay a foreclosure and cure it and be able to modify your mortgage. And finally, Chapter 15 is international. If a company overseas has filed for bankruptcy in whatever their country's version of bankruptcy is and they have U.S. assets, they will use Chapter 15 here for any U.S. assets that they may have. Inevitably, though, you're going to run into debtors who are going to come visit you, and they're going to say, I'm from New Jersey. Forget about it. It ain't happening. There's no way I'm going to file for bankruptcy. I've worked too hard, too long. My family's dependent on it. This business is my life. I'm not filing for bankruptcy no matter what. And you're going to nod your head and smile, and you're going to say, okay, let's talk about it. There are, of course, opportunities to reorganize outside of filing for a federal bankruptcy. And it can be done. I mentioned the Turnaround Management Association before. Those are individuals who dedicate their careers are spent in this space, trying to work with businesses to realign their finances, their business model, and help them get back to profitability. Sometimes it works. Sometimes they end up filing anyway, and we'll talk about that part in a second. But if you're going to go down this road, what is it that you need to do? Well, first and foremost, you need to take a deep dive into your business. And whether or not the current business owners are capable of doing that is a fair question. They're going to need to look at their product lines, their service lines, what's making the money, what's not making the money. They're going to need to look at their cost structure as well as their top line and see what they can get under control. The classic tool that's brought to bear here is something called a 13-week cash flow. And as a financial person, you've seen budgets and cash flow models before, and there's really nothing different here. You're going to break your expenses down into the classic three categories: what's discretionary, what's variable, and what's mandatory. And then you're going to peel back the onion in each one of those categories and see what you can do. You're going to build that 13 weeks out, and then you're going to stress test it. You're going to look at it and see what happens if this happens or if that happens. And then you're also going to build in alternatives and options that if the cash flow doesn't materialize, what's going to happen next? What will be cut? What will be saved? Where will the investments be? It's a continuous process that a business needs to go through in order to realign themselves. It's by no means a static model. Part of this turnaround process inevitably is going to be a conversation with their lender, where they probably have already blown their loan covenants. Maybe if they're in really bad shape, have missed some payments. They're going to need to go to that lender with a little bit of hat in hand and say, hey, don't pull my loan. To do that, they need to have a plan. They need to understand and be able to present to that banker what the issues are, what got them there. Maybe it's a pandemic. Maybe it's they've lost a major client. Maybe there's some other issue going on. They need to be able to present the projections. They need to tell the story about how they're going to move from where they are today back to profitability. The banker's going to want to know what that timeline looks like. And then the banker's going to want to know, what do you need from them? Is it going to be a forbearance? Is it going to be an extension? Is it going to be an overextension on the line? And then the banker's going to smile and say, if I'm going to give you that, what are you going to give me? And they're going to be looking for more collateral. Those are the questions that are going to need to be answered. They may also be encouraging you to plug in a chief restructuring officer, someone, a third party who you're going to pay, who's going to look at the business and try and help you right the ship. Not always an exciting opportunity. Some of the other things you're going to want to look at in this context, and I was reminded by a good friend of mine who I think is listening this morning, who deals with insurance for distressed companies, that you need to look at your insurance coverage as well. Do you have enough? And specifically your directors and officers policy. That's a spot your creditors are going to look at for a potential recovery if you're making some bad decisions. Know where your coverages are and make sure you've got appropriate coverages. Also look at personal guarantees. That's another area where small and mid-tier businesses can get themselves in a lot of trouble if they knee-jerk file for bankruptcy and then the lender says, hey, that's great. Excuse me, Mr. Guarantor, pay me. It's a problem. You need to be sure you're aware of them before you proceed with a filing and understand what's going to happen when you do. There's one other option for you other than bankruptcy if you decide to go down that road, and it's up here in New Jersey, it's called an assignment for the benefit creditors. It goes by a couple of different names around the country. Essentially, it's a state level bankruptcy is the best way to explain it, where you're going to liquidate under state law. Largely a receivership is similar, and an assignee will be appointed, typically by yourself, and they will take control of the business, liquidate it, and pay your creditors out under court supervision at a state level. There's some obviously nuance there between federal and state law, but if you've got a good attorney, they can explain all that to you. But inevitably, the turnaround didn't work, and you're going to need to file. So a lot of work needs to happen before you actually pull the trigger on a filing. There's a lot of homework that needs to be done here. In order to file for bankruptcy, you don't just walk up to the courthouse steps and say, hey, Mr. Judge, I'm filing for bankruptcy. It's done with a petition. The petition is filed with the court. The petition consists of schedules and something called the Statement of Financial Affairs. Those schedules detail all of your assets, where they are and what they're worth. They also detail all of your liabilities. Are they secured, unsecured? Does the particular vendor have a preference for payment based on the bankruptcy scheme? The Statement of Financial Affairs is going to go into some of your history, some of your governance, some of your finances of the recent past, so that there's a more of a transparent picture of what's actually gone on here. Those all take a significant amount of time to be put together, and I encourage you to make sure that they're put together properly. They are signed under penalty of perjury, which means if you understate the value of your assets, or forget some assets, or maybe transfer some assets just prior to filing so that the creditors don't know about them, you're committing a federal crime. Now, I'm not an attorney, but I watch TV and they tell me that's a bad thing. If you're going to go down the road of a Chapter 11 and not just a Chapter 7, you got to do a lot of planning. You got to think about you need to start thinking about your exit. You can't go into a Chapter 11 filing to buy yourself time. It's not going to work. You will end up in a Chapter 18. For the accounts in the room, that's a Chapter 11 followed with a Chapter 7. You need to understand how you're going to get at the exit to the plan and begin to build that with your counsel and financial advisor out of the gate, so that as you're moving forward, you can start putting meat on those bones. That's going to entail projections, liquidation analysis, valuations. You may choose to sell your business or some of your assets in the Chapter 11 process. You're going to need to find those potential bidders for your business or those assets before you file, so that there's something called a stalking horse. Basically, they're going to be the first bidder in that auction process that you're going to go through in court, in the actual court. We already talked about personal guarantees. You need to look at the related party transactions. Modern business is set up with multiple business entities all serving one another, some onshore, some offshore. They're all over the place. There's transactions with individuals as well. There's something called a constructive fraudulent conveyance, which we'll talk more about next week. But if all of those transactions that have occurred between those entities have not been done at arm's length, it's a problem, and you're going to need to address that and be sure you're aware of it before you file. Again, we'll talk about that more next week. It's a big deal. Think transfer pricing, which is very popular, obviously, with foreign-based assets, foreign-based entities, and U.S.-based entities. The same thing applies onshore. You're going to need to evaluate your leases. Think about the retail bankruptcies that are going on right now. Lord & Taylor file. They've got locations throughout the country. Within the Chapter 11 process, they're going to be able to reject some or all of those leases. You need to know which ones you're rejecting out of the gate. If you're going to keep any, those need to be accepted. And finally, the last thing I'm going to highlight here in the Chapter 11 planning process is a communication plan. You've got vendors, you've got employees, and you've got customers. Your employees want to know if they still have a job. Your customers want to know if they're going to be able to fulfill the orders and the commitments you have to them. And your vendors, well, they just got stuck for a whole boatload of cash. and they want to know what's the plan to get paid and why they should be bothering to work with you on a go-forward basis. So let's get into some of the chapters here. We'll talk a little bit about Chapter 7 and Chapter 11. Chapter 7, as I mentioned, is a liquidation. The assets are going to be sold, they're going to be converted to cash and used to pay the creditors. When you file the petition with the court, and this is regardless of the chapter, something called the automatic stay happens. And it's kind of akin to sunrise. All of your creditors are immediately stopped from any further collection activities. Most of the legal activities that lawsuits you may be involved in are stopped cold. You've got a chance to take a breath, take stock of what you have, and position yourself to go forward. Now, obviously, in a Chapter 7, you're not going forward, but that comes into play in a Chapter 11, 13, or some of the other chapters we talked about earlier. But that automatic stay is an amazing and very powerful tool that is available to you. The next thing that happens, and this happens also in a Chapter 11 with a little twist, there's a 341 meeting. It refers to a section of the bankruptcy code. Here you're going to meet with the trustee, and he or she is going to ask you a whole slew of questions about your petition, about your assets, where they are, what's happened, and try to get their arms around what's going on here. I'm going to jump around here, not to hit on all of these. Taxes is an important one. And again, this doesn't matter the chapter. We're not going to get into tax issues. I'll talk about some of them next week. The one I want to highlight here is withholding taxes and sales taxes. These carry personal responsibility. If you've got a stub payroll and you've withheld taxes from your employees, or you've got a sales tax return or excise tax return for that matter that is due either the state or the federal government, and you've collected taxes on their behalf, you need to be sure those taxes get paid in. There's personal responsibility there, and that can create a gigantic mess, not only for the trustee, but for yourself individually. Be aware of that and watch out for it. We'll talk more about preference actions and fraudulent conveyances. Those are those avoidance actions I mentioned earlier. We're going to get into those next week, so stay tuned on that one. The last thing I want to kind of highlight here as a financial advisor is the business shutdown issues. There's a lot of them. When that front door is shut and the trustee says, here, Mr. Financial Advisors, go close this place down, and you do the humana dance, what comes next? What's got to happen here? Well, think about the employees. W-2s need to be issued at the end of the year. There's probably a 401k plan that needs to be shut down. I mentioned the trust fund taxes. You need to get hold of the technology. You need to get hold of their accounting system, as whatever shambles it may be in. You need to recover their back tax returns, vendor invoices. You need to have the accounts receivable information to collect on the outstanding receivables, so that when that customer says, I don't know you that, you can provide that documentation. You need to help with identification of assets. There might be inventory. The list kind of goes on here, and it's pretty extensive. In the kinds of things you need to get your arms around quickly as a financial advisor. Large businesses, I mentioned Lord and Taylor before, places like that are going to have a going out of business sale. That opens up a whole can of worms of issues that needs to be dealt with in terms of where's the inventory, what's it worth, physical retail locations versus back locations. Way too much to get into today, but just know there's a ton of work that needs to be done there, and you will spend a lot of time getting your arms around all that stuff. So let's talk about Chapter 11 a little bit here. Chapter 11, as I mentioned, we're going to reorganize. We're going to try and move forward and recreate our business. I'm not going to touch on individuals because it's a little nuanced. Again, the automatic stay. The 341 meeting here is a little different. Here you're going to be in a meeting with the Office of the United States Trustee. You're going to also, the creditors are going to be invited to be present. You're going to present the issues that got you to this point. You're going to talk about how you're going to get out of these issues, and your creditors are going to be there to ask questions. As a financial advisor, you're going to help develop the information that the creditor body is going to be asking about. Help develop those projections to present the go-forward plan. You're going to be involved in all of that. You're going to be involved in the plan of reorganization and the disclosure statement. That's that magical business plan that is going to ultimately describe how you're going to get out of this and exit bankruptcy. There are monthly operating reports that need to be filed. Anyone in a Chapter 11 needs to file a report with the court every month that talks about and provides the classic balance sheet, income statement, cash flow, all of that information to the court on a monthly basis. If there's going to be a sale of the business or its assets, there's going to be what's called the 363 sale, another code section. You're going to be involved in assisting with that whole process. Some of the other things that will happen is there'll be a claims analysis. We'll talk about creditors in a minute or two, but the creditors are going to fill out something called the proof of claim. And that's going to say the debtor owes me X and I have a priority for my claim because of Y. Shockingly enough, the petition that the debtor put together and the creditor's proof of claim, they don't always meet. And there needs to be a reconciliation process, and you're going to be involved in doing that reconciliation. Tax services, again, we'll talk about that next week, but there is a ton of them. Suffice it to say, you will become intimately familiar with Section 108, cancellation of debt. Feasibility talks about whether the plan is feasible. Can the debtor actually fulfill the obligations that are prescribed under the plan? There's some other nuance in there, but that's, a lot of valuation issues all sit within feasibility that you'll need to get your arms around and be able to present in court, by the way. The final one I'll hit on here is a solvency analysis. Solvency analysis talks about whether or not and when the debtor actually became insolvent. This comes into play in fraudulent transfers. Well, again, I'll talk about that next week. But that point in time when a debtor becomes insolvent, there's something called the Zone of Insolvency as a legal theory. And that speaks to the fact that at the point at which a debtor becomes insolvent, they are no longer focused on providing value for their shareholders, but rather protecting value for their creditors. It's a little nuanced, but there's a ginormous difference there in terms of the way they need to act. And that's that directors and officers policy I talked about before. It also plays into fraudulent conveyances. Under state fraudulent transfer rules, there is a significant statute of limitations. Here in New Jersey, it's 6 years. So we as financial advisors can look back to the activity of that debtor over the past 6 years, assuming they've been insolvent for that entire 6-year period, and try and reclaim assets. So it's a very important piece of information. And I happen to know that there will be, the ABI will be doing, there'll be a presentation on that later in October. But as we start to wind down here, the Afterlife Emergence. So what happens? So you've managed to run the gauntlet. You got through that Chapter 11 or that subchapter 5. Some things now need to start happening. That plan, which is that covenant that you have with your creditors, needs to be implemented. And you're going to be guided by that plan potentially over a period of time. Some of your assets may have been sold in the context of the bankruptcy. Others may be being moved over to something called a liquidating trust or a litigating trust. Typically, those are set up because a lot of times businesses are sold in that 363 sale, and there's just a bucket of stuff left over. It might be preference actions. Those will get poured over into a liquidating trust, which will then be pursued by a liquidating trustee. That cash will then be used for the benefit of a particular creditor body. Fresh start accounting comes into play in a Chapter 11 if there's a greater than a 50% change in control, and some other specific things come into play. And this is GAAP accounting, ASC 852, if I remember correctly, that will need to be put into place. This is typically the purview of Big Four accounting firms are primarily dealing with that. With the advent of subchapter 5, I'm not sure that it won't creep down more into the middle market. And finally, there's tax services. I already mentioned cancellation of debt, but there's a lot more nuance there, and we'll talk about that next week. Kind of final topic area I wanted to chat about was creditor issues as a financial advisor. So you may have an opportunity where one of your clients comes to you and says, hey, I just got this letter in the mail from the bankruptcy court that one of my customers has filed for bankruptcy. What the heck does this mean? Creditors, depending on the size of the amount of debt that they are owed by that particular debtor, may want to obtain their own representation by both financial advisor and legal representation to protect their rights. The creditors, as I mentioned, all of them will have the opportunity to be present at that 341 meeting to find out what's gone on here and what the plan is. Certain creditors, typically the top 20, and if you're in that group, congratulations are in order, I guess. It's not a fun spot to be because that means you're owed a significant amount of money. But the Office of the United States Trustee will invite you to be part of the creditor committee, which will be formed at that 341 meeting in most cases. The creditors committee, as I mentioned, serves on behalf of all of the unsecured creditors involved in the bankruptcy, and they're the unsecured creditors' voice. And trust me, they are heard, and they are heard loudly. They have the ability to kind of direct some of what goes on and make sure that the unsecured creditors are actually getting a dividend out of this process, albeit maybe 10 cents in the dollar, they're getting something. Both the Office of the United States Trustee and the judge look very heavily to the creditors committee and their representation to be able to drive a case and help them make decisions that are appropriate for the creditor body. You may be getting a letter from a trustee in a bankruptcy or potentially a debtor or a liquidating trustee that says, hey, Mr. Vendor, you know that money we paid you in the 90 days prior to us filing for bankruptcy? Now, I know I owe you a whole heck of a lot of money, but would you mind paying that back? Nothing will set your client off more than a preference claim. And again, we'll talk about this next week, but there are certain defenses that are available to your client that after you get them down off the ceiling, you may be able to bring to bear to help them not pay all of that money back in addition to the money that they're already owed. It's not a happy conversation. Fortunately, you're on their side of the fence. They may be able to attain something called critical vendor status. Certain industries, certain businesses have certain vendors, I sound like an attorney now, that provide specific services or products that are unique, that are single source, or there are only a handful of sources around the country. And they can be granted something called critical vendor status. The magic of critical vendor status is that it enables them to get paid on pre-petition debt, which no other creditor is entitled to. Judge obviously hears the petition and the claim to find out whether or not this can happen. They will rule on it, and then it'll be governed by the terms of the agreement. I already mentioned the proof of claim that's out there. That proof of claim it's important that that's prepared properly. Take some time to fill that out. You may be involved in that, particularly if there's a preference to your particular client versus others. Certain vendors there are a number of priorities under the bankruptcy code. For instance, employees get a preference. Customer deposits get a preference. Tax claims get a preference. There's a whole bunch of them. You need to be aware of them. And finally, reclamation actions. It's kind of good news, bad news. If your client has delivered goods within, I believe it's 45 days of the debtor filing for bankruptcy, they can say, hey, give me my goods back, assuming they can be separated. That's the good news. The bad news is once they're added to inventory, they're typically subject to a blanket lien by their lender, and they now belong to the lender. So, good news, bad news, maybe you get lucky. In a couple of minutes we got left here, I'll just kind of hit on what we're thinking about for next week. And that is, as a financial advisor in a bankruptcy, you can't just start working and expect to get and send an invoice and get paid. There's some nuance there, and we'll talk about how you go about that. We talked about solvency before. We'll get a little bit more into solvency, how it's proven, what it's all about, what it means. The avoidance actions, both preference claims and fraudulent conveyances, what they are, how you defend them, how you go about them. We'll get into some of the tax issues, and we could spend a week talking about tax issues, but we'll hit it on some of the highlights. And then get into some of the valuation issues that are present in a bankruptcy. By and large, a lot of it is what you're familiar with across the board in typical valuation theory, but there is some nuance and some places where it comes into play that you should be aware of and get yourself up to speed on. So with that, Alan, I don't know if there've been any questions here. We got about 5 minutes left. Let's see if we get anything that we can answer for everyone.
Yeah, one question we got is, can you walk us through what a Chapter 13 bankruptcy is like for a family that has means or doesn't have means? And what specifically happens with the house?
Yeah, now, so at 13 is going to be largely, unfortunately, driven by legal counsel and a trustee that will be appointed to oversee it. Now, what's going to happen is that petition is filed. The home, so in order to file for a Chapter 13 out of the gate, you need to have some kind of regular income, because you're going to need to put together a plan to work out your obligations over that 3 to 5 year period. The home specifically, assuming you've gotten delinquent on your mortgage, you're going to be able to kind of stay that foreclosure action for a little while. That's only buying you some time. It's still going to need to be worked out under that plan for how you're going to catch up and then go forward. So it's kind of about the 30,000 feet of 13. And quite honestly, I don't spend, as a financial advisor, you really don't spend a whole lot of time in Chapter 13.
Right. When an individual files bankruptcy, is there a tax return for the period of time that the individual is in bankruptcy, and how does that work?
Short answer is yes. Taxes are still always due. The IRS always wants their little slice. For individuals specifically, in a Chapter 7, a separate bankruptcy estate is formed. That estate files a fiduciary return, a 1041 for those of you in tax practice. That individual then, once they file, they go forward on a 1040. There is an election that can be made, and I'll get a little more into this next week, to file a short year return that ends on the day before the filing for that bankruptcy. So there's a little bit of gamesmanship that can be played. It's particularly interesting in the environment where there are pass-through entities, and when that pass-through entity income is reported. There's a recent tax case on that, and I won't steal my thunder for next week about how that gets dealt with.
Okay. And then for another question was, for a CPA getting their feet wet, learning about this, what do you recommend as far as reading or continuing education? I know you said there's an AICPA talk on Monday. There's a replay that people can email you to get the information on that, I guess.
Yep. Just go on the AICPA's website, even on the FES section. I'm sure it's out there. If not, by all means, please email me. I'll get you the link. That's on subchapter 5 specifically. So some of the resources I've used over the years is the AICPA has 2 practice aids on bankruptcy. One's on the kind of the forensic side, one's on the valuation side. They're fairly current. They do not include subchapter 5, but they're very well written by some of the notables out there. On the financial side, the Association of Solvency and Reorganization Advisors has a lot of good content that goes to, and a gentleman by the name of Grant Newton, who actually formed that organization, has a number of publications out there that go both the tax and the reporting aspects that are of interest. And then the American Bankruptcy Institute, although it's more legal oriented, will have a lot of, all of their conference materials is available to all of their members. Membership is under $400, so it's worth the price of admission.
Okay, beautiful. And then real quick, because we did have a couple of questions on this, what is a Section 5 bankruptcy, and how's that different than a normal Chapter 11?
So it's a subset to Chapter 11, so it embodies all of the rules of Chapter 11 are still present. The subchapter 5 then skinnies down Chapter 11, let's put it that way, where what's going to happen is there's not going to be a creditors committee. The debtor will need to, there's a status conference within 45 days with the judge and the trustee to discuss progress toward the plan. And then the debtor's got 60 days to actually present the plan to the court and then move toward confirmation. Unlike a typical Chapter 11, where that plan has got 120 days and can get stretched out kind of forever and ever and ever, seemingly, I've already been at some that have gone on years. And that creditors committee, which is there to kind of constantly provide some friction. And only the debtor can present a plan of confirmation, a plan of reorganization in a subchapter 5. So it eliminates the opportunity for a third party to come in and try and do it. But all the other things you can do in an 11 are still there. But it specifically was designed for small and mid-sized businesses, again, under $7.5 million in debt. A typical Chapter 11, it doesn't matter on the business side in terms of the debt limit, to be able to get into the process and get out of the process quickly at the least possible cost.
And I believe that the judge can simply change the debt structure without the consent of the creditors. So with normal Chapter 11, you had to have a consent of the majority or a supermajority of creditors. Now in a Section 5, the judge is king, right? He just does it. He does it, and so it's going to be much more debtor friendly and much less creditor friendly, I would think.
I would agree with that. And that's why I think it's a tremendous opportunity for small and mid-tier businesses, to particularly those, for instance, restaurants who have just really been beaten up really bad, who just need to get their past behind them. Hopefully someday they'll actually be able to reopen. They could do a subchapter 5 and kind of move through quickly, get reset. They've got good business models and move forward.
Okay, beautiful. So you have Ken's email address here. Please join us at noon next Thursday, August 27, for more good stuff. And especially, and most importantly, Ken's going to show you what CPAs can do in this process as to expand or become your new practice. Right, Ken?
Absolutely.
Okay, and thank you for your dedication, for all you share through your AICPA and other activities. Hope everybody has a fantastic day. May the rest of it be billable. Thank you.